Good day, everyone. My name is Klyza Zyra Andrino from the Department of Legal Management of Beda University. This video will serve as my midterm examination in business protection law. Today, we are presented with two significant issues. The first one being whether real property ownership in the Philippines should be limited to Filipino citizens only, and whether the law on protection of personal property is sufficient to safeguard the rights of businesses to its ownership and property. With respect to the first matter, I strongly agree that ownership of real property in the Philippines should be limited to Filipino citizens only. To do otherwise would be a blatant violation of our Constitution. According to Section 7 of Article 12 of the 1987 Constitution, save in hereditary succession, no private lands can be transferred or conveyed except to individuals, corporations, or associations qualified to acquire or hold lands of the public domain. In the case of Matthews versus Taylor, the Supreme Court emphasized that aliens, whether individuals or corporations, have been disqualified from acquiring lands of the public domain, hence, by virtue of the aforecited constitutional provision. They are also disqualified from acquiring private lands. The primary purpose of this constitutional provision is the conservation of the national patrimony. Our fundamental law cannot be any clearer. The right to acquire lands of the public domain is reserved only to Filipino citizens or corporation, at least 60% of which is owned by Filipino. Moreover, the Supreme Court in the case of Mateo Encarnacion versus Johnson upheld that the rule is clear and inflexible. Aliens are absolutely not allowed to acquire public or private lands in the Philippines, save only in constitutionally recognized exceptions. There is no rule more than settled than this constitutional prohibition, as more and more aliens attempt to circumvent the provision by trying to own lands through another. In a long line of cases, the Supreme Court have settled issues that directly or indirectly involve the above constitutional provision. At best, an alien could have enjoyed a limited right to own lands. Section 8, Article 12 of the Constitution provides that notwithstanding the provisions of Section 7 of this article, a natural-born citizen of the Philippines who has lost his Philippine citizenship may be a transferee of private lands, subject to limitations provided by the law. Stop. In correlation to this, I vehemently disagree in amending the Constitution, which specifically allow foreigners to acquire real estates and real properties in the Philippines despite it entailing advantages on its own. As we try to look around to say that Philippines real estate is fast becoming a favorite among buyers abroad is quite an understatement. In fact, according to an article that was published in ABS-CBNnews.com, Asian investors are buying in bulk various condominiums here in the Philippines. As a matter of fact, it has the following advantages. The first one being foreign investment in real estate will boost the market. Second, different sectors in the Philippines will benefit. And the last one, the Philippines in general may benefit from more substantial investment. Accordingly, if the existing restriction on the participation of foreigners to our market will be lifted, the residential real estate market will boost. This is not to say that the macroeconomic fundamentals of the Philippines do not bring any advantages to our market, but with less restriction, foreign investment can do so much. In addition to this, because of our restriction, particularly to foreign ownership of properties, for how many years the Philippines are being left behind among all its neighbors in Southeast Asia when it comes to attracting foreign direct investment. According to experts, allowing foreigners to own land for industrial and commercial purposes will benefit the manufacturing sector, which will eventually boost employment opportunities for many Filipinos. However, with the opening of the gates to foreign ownership of real properties, we are kind of opening ourselves to more danger. This may open our country to the entry of foreign government, cartels, groups, and other elements who may pursue other agendas which are prejudicial to the basic securities of our people. These basic securities of the country pertain to its defense or external security, internal security, food security, water security, energy security, environment security, and resource security. In conclusion, despite the aforementioned advantages, I still stand with my opinion that notwithstanding the benefits or advantages the Philippines may acquire, the liberalization of the ownership of real properties in the Philippines will cost many Filipino lives. Advancing to our second question, whether the law on protection of personal property is sufficient to safeguard the rights of businesses to its ownership and security, my answer is affirmative. The law on protection of personal property is already sufficient to safeguard the rights of businesses to its ownership and security. Republic Act number 11507, otherwise known as the Personal Property Security Act or PPCA, was signed into law on 17th of August 2018. It provides for a new means and requirement for creating, perfecting, and registering security over personal property in the Philippines. This particular law amended certain laws to make it more encompassing that will cover anything with respect to this matter. It amended laws that were deemed inconsistent. So this includes those laws relating to the creation of pledges and chattel mortgages and registration procedures for security interests over personal property in the Philippines. Accordingly, the following are the advantages of it to the mortgagee or pledgee of personal property. The first one is that the rule on formalities on this kind of transactions have been simplified, thus eliminating the distinction between a pledge and a mortgage, such as the ability of the mortgagee in a chattel mortgage to recover any deficiency from the debtor in cases the collateral does not fully satisfy the debt. So this remedy is not allowed in a pledge since the foreclosure of the pledge will result in the complete extinguishment of debt. So there is also the creation of security interest under the provisions of PPCA, which basically provides that parties are free to enter into any form of security arrangements over movable property as long as or provided that security arrangements are not inconsistent with the provisions of PPCA. In addition to this, there is already a centralized implementation of rules and regulation regarding the mortgagee and pledgee of personal properties. There is also a centralized creation of a valid security interest over personal property under the Philippine law. Moreover, the provisions of PPCA already provide stringent measures in order to protect the rights of the parties in this kind of transactions involving personal property. So under the PPCA or under the provisions of PPCA, the secured creditor may enforce its security through, among other modes of enforcement, the following. The first one is the judicial process or the extrajudicial process, which includes the sale of the secured assets through a public or private disposition, or even the retention of collateral. So any judicial enforcement of securities, including disposition of collateral, will be governed by rules promulgated by the Philippine Supreme Court. So based on the foregoing, I think it's pretty clear that our law on protection of personal property is already